It's been a day, y'all. I've been thinking about making a video all morning and early afternoon, and my husband's car didn't start, so it needed a new battery, but he had to go to a meeting, so I had to stay here and wait for AAA, and then work had been a nightmare while I was gone, and I had to get all the catch-ups on that, and then my parents decided to stop. It was just... Anyway, here I am. I've been thinking a lot about the amicus briefs and the 47.1 stuff, and I'm going to do a little bit more of a law school kind of policy discussion video on that later tonight. But I did want to note that there is an order from Judge Lyman on the Stephanie Jones protective order request. She got her protective order for the documents related to her security company. And I want to explain why, because this is where Van Zandt was first brought up to Judge Lyman. So if you recall, Stephanie Jones Works had filed a motion for protective order trying to stop Wayfarer from getting in discovery communications between Jones Works and the security company that they hired that supposedly were there with all of this stuff when Jen Abel was forced out, when she left. The security company that allegedly was there, took her phone, took her laptop, all that kind of stuff. Wayfarer asked for that in discovery. Stephanie Jones did not want to turn it over, filed a motion for protective order, and said all of this stuff is covered by the attorney-client privilege and the work product doctrine because I hired the security company at the behest of and through and in conjunction with the lawyers I hired at the same time to prepare myself for the legal actions that might arise out of all of the things that were happening in Jones Works in the summer of 2024. So they said, this is attorney-client privilege. It's work product in addition to that. And we're not going to turn it over. They did the appropriate thing, which is to file a privilege log. You can't just say like, oh, it's privileged. You have to actually identify like there's this many documents and you have to, it's a log. It's exactly what it sounds like where you say like, June 2nd, email from Stephanie Jones to Bob Butterworth at Edgeworth regarding blah. So that if somebody is seeking to pierce through that privilege, then they know exactly what it is that they're looking for. So Judge Lyman gave her the protective order. And before people get mad who don't like Stephanie Jones, which, hey, I get it, let me just set the scene for you. Please remember that the attorney-client privilege is one of the most, if not the most, sacrosanct principle in all of law. The fact that clients can talk to their attorneys and prepare themselves and discuss strategies and nobody can ever see what those conversations are is absolutely critical to both the criminal and the civil legal systems. So it is a very, very high bar to pierce through that privilege and get documents that are communications between a client and their lawyer and those working with their lawyer. It is an extremely high bar. And what the judge found is that Wayfarer didn't meet that bar. Okay, so this is part of the order. So look at that top paragraph. He says in the Second Circuit, and remember, he's in the Second Circuit. The Second Circuit is over the Southern District of New York. So he has no choice but to follow Second Circuit law. It's mandatory authority for him. And Second Circuit law is, if you want to invoke the crime fraud exception, this is what Wayfarer was trying to do, to say we can see those communications even though they're privileged because those communications were part of Jones perpetuating a crime or a fraud. That's one of the only ways that you can push through the attorney-client privilege and see the communications. And what Judge Lyman said is, under Second Circuit law, if you want to invoke the crime fraud exception, you have to demonstrate that there is a factual basis for a showing of probable cause that a crime or a fraud has been committed. In other words, you have to have the same level of evidence that a police officer needs to get a warrant, that level of probable cause. You can't just say, well, they did some shady things, and so I think it's crime fraud exception. We are talking about piercing through this sacrosanct idea, right? So he says, number one, you have to have evidence and facts up to a level of probable cause. And number two, you also have to prove that the communications you want were in furtherance of the fraud or the crime. So you can't just say, well, Stephanie was engaged in a crime in 2013, therefore I should be able to see her documents from 2017. You have to do both. You have to present factual evidence, a factual basis for a finding of probable cause, and that the communications that you want were in furtherance of the crime or the fraud. And Lyman said Wayfair didn't do that. And to be honest with you, they didn't. So the first thing he said, my head will not move. I don't know why, but I'm kind of in front of it. But he says, first of all, you didn't even try to argue that the communications were in furtherance of a crime or a fraud. The second element you skipped altogether. You didn't even argue that. And then as for the first element, he just said, this is one of those things where I need evidence. I need actual factual evidence, right? So he says up there, a party must establish, this is a quote from a case, a party must establish a factual basis supported with evidence. And they didn't do that. They didn't provide an affidavit of any kind. They didn't provide communications or records that would back up the idea that there was a crime or a fraud. What they did was explain how the legal demand for papers worked. And he said, that's not enough. That's not evidence of a crime or a fraud. And frankly, guys, he's right about that. It's not. I've been saying it's not. Is it shady? Sure. But it's probably not evidence of a crime, at least not all by itself. You note down there in the footnote, he says this, like, yes, they did provide evidence of this whole thing. And that alone is just not enough. That means he's seen it. He's seen the legal demand. He knows. I've told y'all he knows. And what he's saying here is that's not enough to prove a crime all by itself. And I feel the need to say this because I know other people are going to say the opposite. Under no circumstances is Judge Lyman saying that the legal demand for papers thing is fine. He is not saying that. He does not weigh in on whether it was appropriate, whether it was proper, how that evidence was gotten, whether that evidence should be usable. He has not been asked any of that. The only thing that he was asked is the fact that this happened all by itself enough to establish probable cause for a crime? And he said no. Now, can Wayfarer go out and get more evidence and then come back and ask this question again? Probably. It doesn't say, no. It doesn't say with prejudice, don't bring this up again. So that's probably what they will do. But I'm sure there's going to be headlines that say, judge rules that Van Zandt subpoena is appropriate. And that's not at all what happened here. So spread the word. Now, the only person that this really affects immediately and significantly is Jennifer Abel, because she really wanted those communications to find out what those people were asked to do when they took her phone. And so we'll see if they find some, sort of other way around it. But, I think the judge is right. I think he was, if the legal requirement is that there be facts, and I know that's weird because at this stage of the litigation, I've been saying you don't have to have facts for anything. On the merits, on the claims and the complaints, you don't. But it's sort of like the personal jurisdiction thing with Jed Wallace. The judge can't just rely on you saying in a memorandum of law, oh, this happened. He's like, I need evidence. I need a full basis, just like a judge would need to sign a warrant. I need actual information and evidence to show a probable cause. And I didn't get it. So legally, I think it's the right decision. It doesn't mean that issue is over. It doesn't mean there won't be any evidence about that whole setup altogether. And it certainly does not mean that the judge is saying the legal demand for papers is fine. What it does show is that he's seen it and he's aware of it.